Before I tell you how the people who were supposed to stand beside me tried to use a 9-year-old child as a legal weapon, let me put you inside one moment first. You are sitting in a courtroom, in a pressed grey shirt you have not worn since your wife's funeral. Across the aisle, your younger brother is in a suit that probably cost more than your truck payment. His wife is holding a tissue she has not used, and your parents, the same two people who dropped a 4-day-old infant on your doorstep 9 years ago and called it family obligation, are seated directly behind them like a wall someone built overnight. The judge is reading from the envelope your attorney submitted that morning. The sealed one. The one that took 8 months and every last dollar of savings you had managed to rebuild. And then the judge sets the papers down, looks up slowly, and asks your brother's attorney one quiet question. The attorney's face goes the color of old paper. That was the morning I understood that patience, when it is backed by truth, is the most dangerous thing a man can carry into a room. Before the story gets darker, like this video, subscribe to the channel, and tell me in the comments what city you're watching from. Because betrayal does not always come from strangers. Sometimes it sits at your kitchen table, calls you Dad, and waits for you to stop paying attention. My name is Daniel Howe. I am 61 years old. For most of my adult life, I worked as a civil engineer for a municipal contractor in Columbus, Ohio. Early mornings, late sites, weekends spent reviewing drawings that nobody else wanted to check twice. It was not glamorous work, but it was honest, and it built something real. A modest house on Carver Road with a proper yard, a truck that never let me down, and a savings account I added to every month without fail, because my father had taught me that a man without a reserve is a man at the mercy of everyone around him. I lost my wife, Carol, to ovarian cancer when I was 51. She was 48. We had no children, not for lack of wanting, but life does not always answer that particular request. After Carol, I became quieter, more internal. I threw myself into work and into the house and into the kind of solitary routines that keep grief from becoming something you cannot manage. I had my neighbor Jim across the street. I had my garden in the back. I had the belief, foolish in hindsight, that the worst thing that could happen to a man had already happened to me, and that what remained of my life would at least be peaceful. My brother Curtis is 6 years younger than me. He was always the one who moved fast and explained later, new cities, new jobs, new women, new reasons why nothing was ever quite his fault. When he was 33, he called me from a hospital in Cincinnati and told me that a woman named Petra, someone I had met once at a Christmas gathering, had just given birth to his son and walked out of the delivery room before the nurses had finished their paperwork. He said he was not ready. He said he needed a few weeks to sort himself out. He was crying, and Curtis never cried, so I drove 4 hours that same evening without thinking it through. His son was 4 days old. Dark hair, clenched fists, the loudest cry I had ever heard from something that small. Curtis handed me a diaper bag in the hospital parking lot, said he would be back by the following weekend, and drove away in a direction that turned out to be Phoenix. The first red flag I missed was simple. In 14 months of irregular phone calls, Curtis never once asked how the baby was sleeping. I named the boy Nathan. Curtis had not filed a birth certificate before he disappeared, and a child needs a name before he needs much else. The early months were the hardest thing I have ever done, and I say that as a man who buried his wife. I was 52 years old, engineering a career that demanded full attention, and suddenly responsible for a human being who needed feeding every 2 hours and could not tell me what was wrong except by volume. I took family leave, then reduced hours, then negotiated a remote arrangement with my supervisor, who was either sympathetic or simply did not want to lose an experienced engineer over a personal crisis. My parents, Frank and Lorraine, visited 3 times that first year. My mother held Nathan briefly each time and spent the remainder of the visit commenting on my housekeeping. My father asked on 2 of those 3 visits whether Curtis had sent any money. He had not. They did not offer any either. By the time Nathan was 4, something had shifted in the way my mother spoke about Curtis. Less criticism, more explanation. He was finding his footing. He had a steady job now. He had met a good woman. I noticed the shift, but I told myself it was just a mother's hope and left it alone. When Nathan was 6, Curtis reappeared for a weekend. He brought an expensive toy, called Nathan Buddy, in a loud, cheerful voice, and spent most of Saturday on his phone. Nathan watched him with the careful eyes of a child who has learned not to expect too much from unfamiliar adults. That night, Nathan asked me if the man was going to take him somewhere. I told him no. I saw Curtis register my answer from across the room, and something in his expression shifted in a way I filed away without examining. By the time Nathan was 8, my parents had begun asking pointed questions. Whether I had looked into formalizing the arrangement legally, whether I thought Curtis deserved more involvement now that he had stabilized, whether I had considered that Nathan might benefit from knowing his father. Each question arrived wrapped in concern, but landed like the corner of something harder underneath. The discovery came from a mistake so ordinary it almost felt insulting. My mother sent a group email to the wrong address. She meant to send it to Curtis. She sent it to me. The chain was 5 months long. My parents, Curtis, and his wife Carla, discussing a family law consultation they had attended together. The language was not emotional, it was operational. Notes about biological parental rights and the conditions under which absence could be legally excused. References to how courts respond to petitioners who present as reformed and family committed. A message from Curtis dated 4 months earlier that read, "We need to move before he gets ahead of this. He, me, the man who had taken unpaid leave, reorganized his entire professional life, learned to swaddle an infant from a YouTube video at 2 in the morning, and spent 9 years making sure Nathan knew that not everyone who was supposed to show up for him would fail." I read the chain twice. I did not raise my voice. I did not call anyone. I turned off my monitor, walked to the back porch, and stood in the garden for a long time while the reality of what I was reading settled into something I could actually use. The following morning, I called an attorney named Robert Finch, a family law specialist in Columbus with a reputation for being methodical in a way that opposing counsel consistently underestimated. I presented the situation without emotion, and he appreciated that. He told me to begin documentation immediately and to tell no one what I was doing. Over the next 3 weeks, I built a record of 9 years. School enrollment documents bearing my signature on every line, pediatric visit histories, immunization records, Nathan's therapy notes from the anxiety counseling we had begun when he was 7, each one identifying me as his sole psychological parent and primary caregiver. Bank statements covering every dollar spent on food, clothing, school supplies, medical copays, and extracurricular activities. Birthday photographs dated year by year, report cards, his soccer league registrations, the lease extensions I had signed specifically to keep him in the same school district for continuity. Robert then recommended a private investigator to examine Curtis and Carla's financial situation and recent conduct. I agreed immediately. Because I had learned something important from 9 years of watching Curtis operate. Men who use legal language before they use honest conversation are not working from love. They are working from calculation. And calculation, when you are calm enough to study it, always leaves a trail. Curtis and Carla filed their petition 10 months after that misdirected email. They arrived in court looking rehearsed and expensive, Carla in a neutral blazer, Curtis with a new haircut and a prepared statement about personal growth and a father's right to know his son. My parents sat directly behind them, and my father had the expression of a man who believes the outcome has already been arranged. Their attorney painted me as a grieving widower who had allowed temporary caregiving to calcify into possessiveness, a man who had confused obligation with ownership and denied a child his biological birthright. Then it was our turn. Robert did not perform. He documented. 9 years of evidence presented without flourish. Teacher testimony. Nathan's counselor's clinical assessment of his primary attachment figure. Medical records. Financial records establishing sole support. Then he submitted the sealed envelope. The investigator's report inside revealed that Curtis and Carla carried significant joint debt and had made repeated inquiries about a survivor's pension benefit from my late wife Carol's estate, a benefit that would become accessible through Nathan if Curtis established legal custody. There were financial planning records discussing asset positioning in a minor child's name. There were sworn statement inconsistencies. And there was a recorded conversation in which Curtis told a business associate he only needed the arrangement formalized for 18 months, and then they could restructure. 18 months. Nathan was a timeline. My son was a restructuring plan. When the judge finished reading, he set the folder flat on the bench and looked at Curtis for a long moment. Then he said, quietly and without any particular drama, that this court does not exist to serve adult financial planning. Curtis did not flinch visibly, but I watched his wife turn to look at him with an expression that told me she had not known everything either. The petition was denied in full. The judge ruled that Nathan's best interests required the preservation of the only consistent parental relationship he had ever known. He cited 9 years of sole documented caregiving, Nathan's established psychological attachment, the complete absence of meaningful involvement from the petitioner, and the material misrepresentations embedded in the petition regarding motive and financial circumstance. He noted that biological connection, while relevant, does not supersede the welfare of a child who has known only one home, one parent, and one version of safety. Robert shook my hand outside the courtroom doors and said nothing for a moment, which I respected. Then he said that Curtis had made a fundamental error. He had assumed I was too focused on raising the boy to notice what was being built around me. My parents did not approach me after the ruling. My father walked past me in the corridor without speaking. My mother looked at me once, briefly, and then looked away. I did not follow them. I had nothing left to say to either of them that the court record had not already said more precisely. The weeks after were quieter than I expected. Not empty, just settled. The way a house feels after a long storm has finally passed, and you walk through each room checking for damage and find less than you feared. Nathan slept without waking that first Friday night after the ruling. I sat in the kitchen at 5 in the morning with cold coffee and listened to the house breathe. Jim from across the street came over Saturday afternoon with a 6-pack and did not ask many questions, which was exactly the right thing to do. We sat on the back porch and watched the garden and talked about nothing important for 2 hours. Nathan came out eventually in his socks and sat between us and ate half a bag of pretzels and announced that he wanted to learn woodworking. I told him we would start with something simple. He said he wanted to build a shelf. I said that was a reasonable place to begin. It was the most ordinary conversation I had ever been grateful for. What I know now is this: a man can be used without understanding he is being used if the people doing it are patient enough, and if he is too busy doing the actual work to look up and examine the architecture being built around him. I was not a placeholder. I was not a temporary arrangement. I was a father, built one ordinary day at a time over 9 years in the way that fathers are actually built, not through biology, not through courtroom petitions, but through presence, through being there when the fever spiked at midnight, through sitting in the school parking lot 10 minutes early because a boy with abandonment in his history needed to see your truck before he walked out the door. Curtis wanted Nathan on paper. I had him in reality. And when the judge read what reality actually looked like documented across 9 years, paper turned out to be the weaker thing. If this story stayed with you, subscribe and leave your city in the comments. It means more than you know. I will see you in the next one.